Ready to this week's happy hour session. We're very pleased to have Charles Dunham with us. Charles works in Houston for it's Greenberg Traurig. Charles.
Greenberg Traurig, yes, sir.
Okay, and how long have you been with them?
Well, I've been with GT for about a year and a half now, but I've been practicing as a healthcare attorney for about 13 years now.
Yeah, exactly. We're very pleased to have Charles with us today. He's going to be giving us some helpful tips on contract negotiations. Just before we get started, I wanted to point out that next week we'll be back to kind of one of our conventional happy hours. We'll be discussing follicular tumors. Then we're going to take about a 3-week Christmas holiday, start up again in January. And in early February, we're going to have another kind of board review prep for the upcoming Dermpath core exam. So just wanted to put that on your radar. And that being said, I'll go ahead and turn it over to Charles. And Charles, you wanted the attendees to use the chat box, chat room?
Yeah, I pulled up the chat box, so hopefully I should be able to see when anyone has a question. It'll pop up and I can respond to it. Anytime during the presentation, feel free to submit those questions, try to ping someone if I'm, for whatever reason, not seeing it, but I did pull up the chat box. And so feel free to do so throughout the presentation. Welcome, everyone. Appreciate you taking the time to attend this lecture series here. And we're going to talk about contract negotiations as a W-2 employee or 1099 contractor. My practice is focused in on contracts, negotiations, and large mergers, acquisitions, transactions in that space, primarily with healthcare providers and suppliers. I do represent from hospitals down to group practices. I engage in a lot of work in the diagnostic and clinical lab space, telehealth, telemedicine. And so I've been asked to speak to you about this particular issue, and it's somewhat high level, but it's also going to, however much you want to get into the weeds and your questions as we go along, I'm happy to field that. But let's start off with just the basic concept and the distinction between, which is very relevant, the distinction between an employment status as a W-2 employee or if you're hired as a 1099 contractor. It has a number of distinctions in its nature. W-2 employees typically are at will employment, but you can have terms of which you are engaged, terms to which you need to be given sufficient notice of termination, period to make transition. And especially with professionals and healthcare professionals, it's important to have that transition period for your patients. In fact, there are obligations in most states to give notice to your patients, being your employer giving notice to his patients as well as you, if in fact you do leave their employ, so that they can continue to receive care. And then there's also a big distinction between the employee benefits. As a 1099 contractor, you would not and are not entitled to receive certain employee benefits pursuant to the IRS code. Like I said, this is a high-level discussion, so we're not going to get into the weeds there, but there are a number of examples, 401ks and the like. You would not be entitled to receive that as a benefit if you were a 1099 contractor, whereas you would if you were a W-2 employee. And a number of times, part of the negotiations for potential partnership, especially when you're in smaller group practices, has partnership offerings built into those relationships. I see that with W-2 employees and not necessarily with 1099 contractors. And the concept of a profits interest is essentially a grant in receiving the profits that the group practice will otherwise issue out to the partners. You can receive those type of profit interests, but you can only do so if you're a W-2 employee. Fairly complex tax issue and rules, but things to take note of in the distinction, and what we do take note of and advise when we're advising our individual physician and other healthcare professionals who are negotiating these contracts. A last note there, the IRS revenue ruling you'll see on that slide here, that actually gives you a framework for determining whether or not you meet the definition of a 1099 contractor. The government needs to generate revenue from taxes, and you're taxed differently, and your employer is taxed differently if you are in fact a W-2 employee versus a 1099 contractor. So you can make specific reference to that ruling there to see the type of direction and control and those elements of how you engage in your practice that would warrant whether or not you actually meet the definition of a 1099 contractor or a W-2 employee. So let's get into terms and conditions if you are negotiating a contract for hire. The typical language that you will see are the duties and responsibilities in your role. Obviously, in those duties and responsibilities, there are also those obligations of your employer that will be set forth within that agreement. Those can be, very lengthy or minimal, essentially performing your services as licensed and trained and to the highest standard, and then can be very specific when you get into administrative functions that you have to perform over and above your actual professional services that you'll be rendering to patients. Part of that, more detail, is obviously in your schedule and call schedules. Generally, there's flexibility there to be changed, but it's something that you can negotiate depending on that, your position and what you need as far as personal reasons. You would want to set that forth in writing to the extent that you can. The big piece, probably the big piece for everyone, is base salary and productivity bonus. We're going to talk about that more in detail in the next slide. Again, like I said, there's a distinction in between the type of employee benefits that you could receive depending on whether or not you're W-2 or 1099, term and termination, so you know how long you're committed and what that period of time will be. And then the last thing that we will touch about in more detail, in great detail, are restrictive covenants. Restrictive covenants mean those type of activities that you would be precluded from engaging in, such as a non-compete or non-solicitation. Again, we'll talk about that in a little bit more detail in the subsequent slides. So compensation models and methods I've outlined here for you. Just some recommendations while you're engaged in the initial negotiations and while you're learning more and more about the position that you're interested in accepting. Of course, in the compensation piece, you want to necessarily understand, and to the extent that you can, how other physicians and healthcare professionals are in similar specialties compensated in your region, and to ensure that you're being compensated on a fair market value basis. There are actually publications out there that maintain that information, so you can get a sense of that, and they will obviously break it down by region, by specialty, and by experience. Some of them are publicly available, others you have to purchase. But we, as a firm, will generally have offices all over the U.S., so we will generally have a sense of that type of information for our clients based upon contracts that we've negotiated on behalf of others. There's obviously confidentiality there, but we can give you a ballpark of what we're seeing in specific region and specialty. The benefits, again, are a huge component. Even as an attorney myself, it's a huge component for me in negotiating and understanding what the additional perks are with the employment. And certainly for healthcare professionals, you want to understand the coverage for malpractice insurance. You want to understand if your employer is going to cover your licensing fees and any medical staff dues, specifically additional costs for CMEs. and then the general paid time off. What's that look like? We all work very hard, so sometimes we don't necessarily get the paid time off that we'd like. But understanding what that is, what that looks like, 401k plans, retirement options, all things that are either set forth in an agreement or for larger organizations, they have that in general employee policies. So essentially everyone's treated the same for a number of those employment benefits. And then productivity bonus. There's multiple ways by which that this can be calculated. It honestly varies by the type of organization that you're working with, and size and scale. It's not necessarily guaranteed that you will have a productivity bonus, but these are three examples that you see most frequently. The first being compensation simply based on a percentage of collections from the services that you rendered. There are certainly factors to consider there. This method otherwise will have variability based upon payer mix, contract rates, how good a contracts your employer has with especially commercial health plans, Medicare Advantage, all those that have variable rates that can be negotiated as compared to Medicare or Medicaid that have fixed fee schedules and those amounts. So that obviously is important to understand to get a sense of what that could look like. And then most people don't talk about this, but the effectiveness of the billing and collection departments within the organization that you work. And you can perform the service, but that doesn't necessarily mean bills are going out properly, collections are being handled properly, and appeals to those claims. Those will all impact the compensation that you receive and collect at the end of the day. So it's important to take that into consideration. The second model is compensation based on a percentage of profits less expenses. So this is a little bit more of a complicated formula, if you will, rather than a straight percentage of revenues collected. And there's some cons because you don't have control over the expenses and how they're allocated. But you can be fairly specific about that within your agreement, and you can carve out certain language, depending on what position you're in, to negotiate it, that the contracts themselves and what is contributed as far as overhead costs and specific costs to you as the provider can be specified in the agreement. So all these types of issues vary based upon how significant type of negotiations you're engaged in. Of course, negotiation depends on your position to be able to negotiate and how extensively that you're able to negotiate. But certainly if you're a coveted candidate, then it gives you all that more room to negotiate. Then the last is compensation based upon the WRVUs. This essentially is developed and a concept developed from CMS. There will be sometimes that some slight changes every year, and this we see more often in the hospital or clinic setting as a method by which to establish compensation and/or productivity bonus. And so, it really does get fairly complicated, an issue and topic that that'll probably can warrant its own presentation all by itself. But understanding it better and comes over time, familiarizing yourself. I think that this is honestly something that may be not phased out, but transitioned a little bit differently as we move into more value-based care. I don't think that hospitals and institutional clinics and other institutional employers are fully moved in that direction yet. But we are working with some larger organizations on these type of value-based arrangements, especially in negotiating with outside practices. contract with the hospitals. So I'm just checking the chats, making sure I don't see any questions in the chat box. So I'll continue on. The term and termination, this is again something that's relevant, and I wanted to highlight as far as negotiations are concerned. As we discussed, we could have a set term. Generally, they're evergreen, so evergreen meaning they'll just renew on an annual basis with some amendment to your compensation, but the terms of the agreement will auto renew unless terminated in advance. Again, remember, if you truly are a W-2 employee, you can be terminated like any other employee. It's an at-will status. You know, one of my original mentors when I was practicing and learning about labor and employment indicated to me, yeah, you're an employee, you can be fired because you come in on a Tuesday with a red sweat, right? I mean, so long as it's not something that's discriminatory and a protected class, you can be terminated without cause, and there's, you know, limited protections there outside of federal protections for discriminating certain classes, and then what's set forth within your contract. All right, so we do have a couple questions that just came in. So these ones are not necessarily specific. Well, this was probably the tail. We're talking about malpractice coverage. So it says approximately how much does tail coverage usually cost if not covered by the contract? Well, obviously that will vary based upon your specialty and the potential exposure, right, for malpractice suits and damages. It can vary then, obviously, of course, by the coverage limits, the minimums that you want to impose and put into place. So it's kind of hard to be specific about the amount, but my note on tail coverage is make sure you understand what that, and for those who don't understand what that means, it essentially means when your contract and your employment relationship ceases, if the employer maintain a claims-based policy as compared to an occurrence-based policy, the claims-based policy, if it ends upon your termination, if there's a lawsuit after your termination, that policy no longer applies because it only applies when the claim was filed, as compared to an occurrence-based policy, which would apply indefinitely for at least for the period of statute of limitations for which somebody could file a claim. So obviously, occurrence-based policy is more expensive. Generally not the choice that an employer would typically choose. And that's why tail coverage, that is a policy in place to protect you after that employment, is relevant to understand. Let's see, another question. Any specific advice for forming a partnership with an existing physician? That's going to be outside of the scope of this discussion. This is essentially contract negotiations and for employment. And there are a lot of facets to, stepping into that relationship. I'll give you number one rule of thumb for that, though, to not evade the question, if you will. Understand what the current construct of that partnership is. You need to understand what their operating agreements or bylaws look like, what their current financial status, all of those things, not just what you're envisioning. Very important to understand the dating process, if you will, and the due diligence when you're actually starting to go down that road, and you'll uncover a lot of things that you didn't know or weren't privy to just simply as an employee. Is MGMA data a good gauge for dermatologists starting out? Yeah, I think that it's fair. and that's one of the questions here. I think that can be a fair assessment. There are more detailed and specific type of publications, but not all of them are public, and especially, understanding the reporting associated with that. What do you see most commonly as the compensation method? Percentage of revenue, RVUs, WRVUs for dermatologists in the clinic owned by another dermatologist. Well, if it's a clinic owned by another dermatologist, we essentially see, I see the majority of the instance being a percentage of revenue, and some simple formula of that nature, just because of the ease of which to calculate that, and it's less sophisticated, and honestly is pretty straightforward, sort of an eat what you kill approach, and obviously covering the overhead costs of the practice. But that is what I typically see in most instances with in that type of setting. So that's those questions for now. I'll keep going with this piece, and feel free again to continue to submit that as you have additional questions. So patient notice, that's something I think, if there is employment termination, and you want to make sure that, number one, that notice goes out, because otherwise it's professional misconduct, that you haven't given your patients proper notice that you're no longer going to be with that organization or group or what have you. But it's also relevant to your ongoing career to make sure, and you can negotiate this in advance, to make sure that when that notice goes out to the patients, that those patients are given the opportunity to contact you, and the best opportunity for them to do that is by making sure that your new contact information is included in that notice. So that's not necessarily required in order to meet your professional conduct requirements. And most employers don't want to provide your forwarding their new contact information. They want the patients to have to come to and call into the practice, and so that they can continue to have those patients within their practice and on their patient list. So it's something that you can negotiate in advance, rather than having to try to deal with it at the end of the transition, in the event of termination, voluntary or involuntary if you are terminated. So something to think about. So let's move on to restrictive covenants and non-competes and non-solicitation. Hold on, there's one more question that came in. Have you noticed the percentage of incentive collections drop significantly due to COVID? Previously, I had seen 40 to 42% of collections after $1 million was considered a strong deal. Is this still the case, and is this still a feasible figure to obtain when starting out? Well, I'd say 40 to 42% is a strong number, but if you are generating over $1 million right off the bat, it's not out of the question. But 40 to 42% is a pretty strong number, especially well, it says of net collections, so that means there's an offset there of from gross revenue. So I guess that's more in line. Typically, we're seeing somewhere between 25 to 35 of gross, so that doesn't seem unreasonable. Have I seen a change in that? Well, obviously we've seen collections drop significantly. Some practices having it for a period of time, losses of 80%, only doing 20% of the work they had previously done. I've seen that uptick again. Right, it's coming back. Certainly, more individuals are going and getting their annual screenings, and the restrictions that were imposed by a number of states as far as those type of visits being lifted. So that's been a positive impact for sure as a result. But they dipped down quite significantly. our volume for a period of time. So non-compete, non-solicitation, I have the slide up here for you to understand the distinction, and it is a very relevant distinction. I think the simplest, non-compete addresses your ability to go out there and perform the professional service that you're licensed to perform. Whether it's performing it as an owner or a manager, employee, or advisor, it can be very broad. And non-solicitation is simply associated with how you go about generating business, or how you go about competing in a way by soliciting clients or customers, employees or agents, or any vendors or suppliers that you learn of during your employment. So you can have a non-solicitation provision, but not be restricted from engaging in any professional services in any area. And non-solicitation is actually a fairly effective way to prevent competition, prevent soliciting patients or customers and the like. But for a lot of the time, everyone seems to continually just want to put a non-compete into place, and that's fine. But the non-compete has restrictions and on how and the burden that you're imposing on the employee, you as the professional, whereas non-solicitation has no restrictions. You can essentially put any time period, geographic area, and during and after the relationship. So we're going to, since there is no regulatory framework for non-solicitation, understand that it exists and it can be very effective. But we'll focus in on non-compete, which does have regulatory framework. The areas which this non-compete can work is time period, 6 months, a year, 2 years. It will vary, and the geographic area, 5 miles, 10 miles, 25 miles, an entire metropolitan area, and then obviously a non-compete can exist both during and after the relationship. So moonlighting type of activities during your employment can be restricted. Those can be restricted pretty much without much regulatory or state law restrictions or case law. And most of it's really focused in on that after that relationship element. So I want to give you some specific examples in states that might be relevant, and how they otherwise currently exist. California is a fairly favorable state to the employee, especially professionals. There is a statutory prohibition on post-employment non-competes, except in sale of business. So it means if you sell your practice, and part of that compensation for selling your practice is that you're not going to compete against the buyer, obviously that can still apply. There are non-competes that carve out in case law, but it wouldn't apply to you because it's everything prior to 2017 that were grandfathered in, if you will, under the law. In Colorado has an interesting additional color, I should say, to non-competes. They allow the imposition of damages if actually reasonably related to an injury suffered against the physician for any breach of an agreement, which means, and not only do they allow it, but they also allow specifically to impose damages within the agreement and define them if it could be reasonably related to that relationship. And so, that's an example of one state that's completely prohibiting it, all right, except in limited circumstances, and another state that allows it and even recognizes the ability to impose some damages. Then even more color on Colorado is actually an amendment in 2018, which I find interesting, which may not apply to this group, but no, it might. That there's a carve out that says the physician may in fact compete by informing, actually solicitation, if you will, but informing their patients and continuing a practice with that patient if that patient has a rare disorder, which essentially means that you can't be prohibited from competing with a certain patient population in Colorado. So here's Louisiana and Massachusetts are examples. There's Massachusetts. There's a statutory prohibition, but then there's 8 carve-out exceptions that apply. Or I'm sorry, in Louisiana, and then there's 8 carve-outs that apply in Massachusetts. There is a statutory prohibition on physician non-competes. So California was broad, anyone non-competes employees. Massachusetts specific with respects to physicians, and restricting your right to engage in the practice of medicine in a particular area for a defined period of time. So, again, this is an example of how each state honestly treats it differently. And so when you're going in and depending on where you otherwise accept employment, the non-competes, how they're crafted, enforced, all alike will vary, and you need to understand that. We do a lot of, because we have offices all over the U.S. We have to familiarize ourselves with the non-competes in all of those states. I have labor and employment counsel that I consult with to make sure that not only if our clients are imposing the non-compete, but if a client comes to us and asks if the non-compete is enforceable, and we evaluate it based upon the state law and the case law that applies. So again, here is an example of a few other states, and I like Texas in the sense that again they provide a little bit more color, right? They permit the non-competes, but they essentially define better and more clearly how that non-compete can exist. And in fact, in Texas, they also have a provision which is fun that allows the physician to actually buy out the restricted covenant for a reasonable price. And in a lot of instances, we negotiate that up front what that reasonable price would be. It can be, and the courts can take a blue pen to it and say that's not a reasonable price, and it can be lower, so on and so forth. Of course, the courts aren't saying that it has to be higher, but they have seen the courts indicate that the amount's not reasonable and set that reasonable amount on their own. And I think then on the last slides I have questions that I get where, because different states vary, right, and have different interpretation. I like to impart what the AMA. The AMA is not opposed to restrictive covenants because obviously some of the members are owners of practices and employers and so on and so forth. But there was a quote a while back that one of the former AMA presidents about how they believe, she believed that the non-competes disrupted continuity of care and patient choice and all of the like. But I've not seen them take a different position on it, nor lobby in any particular way on behalf of physicians as a result. So we have a question that came in here. And so this is something that relates to these non-competes. And if you're being recruited, I would check out this CMS advisory opinion because it discusses what type of non-compete can in fact be imposed and still be compliant with Stark law if you're being recruited. Again, something that you can reference on your own at CMS advisory opinion 2011-01, and it's pretty clear and straightforward. So the question came in, can non-compete deals cross state lines? with the large conglomerate of advanced derms, if you are employed by one, does the non-compete translate for other advanced derm practice in other states, the one you were originally hired in? So that's a jurisdictional question, and my position on that, and I think the courts would, agree, is as an employee, you are otherwise designated to a specific state as far as your employer is, and where they indicate that you are an employee of what state. Now, if that's, you have an employer and their base of operation is in Florida, and for whatever reason they identify you as a Florida employee, but you're actually in Texas and practicing in Texas, the fact is that Texas law, both states will likely apply, and the more stringent one, the one that's more favorable and protective of you, is what I would argue would be applicable, especially since you're conducting the work in there, and the intent is to, address residents and physicians that are residents of and practicing in that state. So I would say Texas law would trump that in that scenario. See, I am a Derm resident. Actually, I think that might be some matter. Type of employment. I don't know the answer to this question. It's about visa status for employment and whether or not employment means a W-2 or a contractor. We have immigration counsel in our Philly and New York office in DC that I consult with on a regular basis, who would be able to answer that question off the top of their head. So I don't want to go out on a limb and say one way or the other, because honestly, it's not necessarily not my practice area. But that is a unique question. I'm happy to try to get that quick answer if you'd like to ping me offline and see if someone can answer that within our practice group and our immigration practice group. But other than that, I've gone through the presentation. Hopefully for happy hour, some of you actually were drinking. But if you have any other questions and further follow-up, happy to answer that. Dr. Davis, if you have any questions or anything to follow up before we go.
Nope, it's been wonderful, Charles, and they do know how to get in touch with you if they have any questions.
Great. Let's see.
There are a couple more questions on.
Yeah, it looks like a couple came up. Paris has one here. I think.
Fee structure for the firm. I'll take that offline if somebody wants to reach out to me. You talked about the various pay schemes and productivity bonuses. In your experience, what things are negotiable? Well, obviously pay as a base salary is always negotiable. Or at least that's my position. I've always negotiated even in my employment. Productivity bonus and the actual formulas that are implemented, again, it will vary based upon the size and sophistication of an organization. So if an organization like a hospital already has a construct for WRVUs, and that's what they essentially operate on, it's very unlikely that you're going to be able to move out of that formula. And so that's why it behooves you to understand it. But with the smaller or closely held group practices or clinics, there is certainly room for negotiation. I find more often than not, they will have a construct that they will work from typically. So they may say, well, this is how we award bonuses, and this is our structure. But obviously, the size and sophistication of an employer will give you a lot more flexibility in negotiations, to be very honest.
Looks like a couple more popped up, Charles.
You recommend that we work with a contract lawyer in our own state, given the variability in state laws and perhaps differences in reasonable. What is the best method for finding a contract lawyer? Well, actually, Sure, if you can find somebody within your state that is, again, that issue is more narrowly tailored to two things. Number one, the non-compete framework, which is pretty easy to learn, depending on the state. And then number two, some of the malpractice insurance and limits. What I would recommend above anything else is to identify an attorney that actually has healthcare experience, knowledge of working with healthcare providers and suppliers, negotiating and familiar with the type of language within those agreements, rather than a pure business attorney. I couldn't tell you how many times I've looked at agreements that totally overlook from the organization to the employees, critical issues that are healthcare and health regulatory related. So that would be my, recommendation. There's a reason why the specialty exists. In your experience, how often have employees renegotiated their contracts? Every 1 year, 3 years? Once you, like I said, most agreements are evergreen in the sense that they have annual renewals, and you will find that if you negotiate it properly, that you will have a provision in there that has the parties will revisit the compensation structure on an annual basis. And there that can vary. I mean, that can be a 1 or 2 year period. But I've never seen anyone negotiate and say, well, we'll revisit my compensation 3 years from now. I've never seen it, longer than 1 or 2 years for sure. I've seen some outside contracts where important things were not discussed. What are some things residents don't often think about or forget to ask? Number one, I think the most important one is, and I raised it before, is tail coverage. And a lot of the things that I would highlight that are often overlooked is, what do you do if the relationship otherwise ends, right? The transition period. I don't care if it's a professional, licensed professional in transition, or just a vendor agreement. And what do you do with the transition? That's often overlooked. You generally just see termination provision. What happens after that? And so I think, the tail coverage, how that's going to be addressed if there's not an occurrence-based policy in place is really important. How you otherwise handle specific transition of your patients that you've committed yourself to, treating and that rely upon you, and also serves as the basis for your growth of your practice, right? Being able to maintain patient relationships for a long period of time. Those are two really important things to think about that I often see overlooked, and certainly are things that are overlooked when you're dealing with just a pure business type of, contractual attorney who doesn't understand the healthcare arena. Most everyone does focus in on the compensation, but look to the nuances of the compensation. Look to, some of these agreements are fairly sophisticated, but one of the things that clients don't think about is, all right, what happens if those dollars and cents get recouped? For no fault of your own, right? You delivered the service, there was some billing error or something of that nature. Are you impacted by it? How might you be impacted by that? Especially when you're talking about your bonus structure. And look for language that might address that being offset. That's where I was getting into the discussion about sort of reliant upon how good or bad the billing and collections group, unit, individual within your employer is, or an outside vendor is, to be honest. You mentioned, what are the resources to find out how much other MD in the same specialty make in the area? Some of the, so VMG has think this VMG here in Texas is a pretty good resource, and they're across the country. I like having that acronym wrong in my head. But there are sort of valuation companies, not sort of, there are valuation companies out there that will serve in a role to assist hospitals and larger employers to determine what is fair market value compensation. And they gather that information on a regular basis for that purpose. But you can benefit from that when they share some of that information. It's not often public, but you can, I mean, sometimes you can pay like $100. Well, guess what? $100 well spent to get that information to understand within your specific, region, what that looks like. Of course, word of mouth, to the extent that people are willing to share that. It's generally not your peers that are willing to share that, but some people who've been mentors to you or outside that will share that kind of information. I mean, I get a lot of that information from my own clients about what they know is in the market, what's going on, as do my other colleagues around the country. So I think that's all the questions I see coming through now.
Well, that's great. We sure do appreciate it, Charles.
You bet. My pleasure. Hopefully it was informative, and let me know if you otherwise need, anyone has a follow-up question. I think there was one question on the visa. I'm happy to ping my colleagues to address that one because it's fairly pertinent, and I'm sorry I just don't know that arena very well in immigration work.
Charles, would you like to share your email, or do you want us to just pull them together to education at Sagis DX and forward it on to you?
Yeah, that's fine. You can share that way. Actually, it's funny. I usually have just sort of an end slide that has my email, but I guess I didn't put it on this when I was pulling this together. But it's just for everybody who's on. Oh, I can do this.
I just posted it.
Oh, you did? Okay.
Great.
That's correct. Yeah.
Thank you so much.
Thank you.
Have a nice evening.
You too. Bye,
Bye.
everyone.